2311 Racing and Front Row Motorsports filed an antitrust lawsuit against NASCAR. This legal action, headed by NBA legend Michael Jordan's 2311 racing team, challenges the very foundations of NASCAR's business model and control over the sport. At the heart of this lawsuit were allegations that NASCAR engaged in anti-competitive practices, specifically regarding its charter system. The teams claim that NASCAR and CEO Jim France have used anti-competitive practices to prevent fair competition in the sport, additionally accusing the organization of unlawful monopolization of premier stock car racing in order to enrich themselves at the expense of the premier stock car racing teams. The dispute centers on the charter agreements, which function like franchises in NASCAR. These charters guarantee teams spots on the grid, prize money, and other benefits. However, they also include clauses that prevent teams from suing NASCAR on antitrust grounds. The legal battle began when NASCAR presented a new charter agreement to teams in September, just 48 hours before the playoffs began. While 13 of 15 organizations signed the deal after more than 2 years of negotiations, 2311 Racing and Front Row Motorsports refused to sign. 2311 Racing, co-owned by Michael Jordan and Joe Gibbs racing driver Denny Hamlin, along with Front Row Motorsports, owned by Bob Jenkins, took issue with the terms of the agreement. They argue that NASCAR's terms would severely limit their operations and financial viability. In response to their refusal to sign, NASCAR rescinded the charter extension offers to 2311 and Front Row. This move left the teams in a precarious position as their current charters are set to expire at the end of the calendar year. The teams then filed for a preliminary injunction seeking to maintain their charter status while the lawsuit proceeds. They argued that losing their charters would cause irreparable harm to their businesses, potentially leading to the loss of sponsors, drivers, and fans. However, U.S. District Judge Frank D. Whitney denied this request on November 8th. In his ruling, Judge Whitney stated that the teams failed to demonstrate present, immediate, urgent, irreparable harm. He viewed their claims as speculative and possible rather than imminent. The judge wrote, "Although plaintiffs allege they are on the brink of irreparable harm, the 2025 racing season is months away. The stock cars remain in the garage. At this stage, the teams are no closer to irreparable harm than they are to the command, 'Drivers, start your engines' at the first race of the 2025 season." This denial was a significant setback for 2311 and Front Row. Without charter protection, they face the prospect of competing as open teams in 2025. This status denies them an equal share of revenue, a guaranteed spot in the field for races, and other benefits provided under the charter agreements. In response to this ruling, the teams initially appealed to the U.S. Court of Appeals for the Fourth Circuit. However, they later withdrew this appeal, citing changed circumstances in the underlying case. These changed circumstances led to a new development in the legal battle. NASCAR modified the 2025 open agreement for all teams by removing a clause that prevented them from bringing legal action. This modification allows 2311 and Front Row to race as open teams in 2025 while continuing their lawsuit. Jeffrey Kessler, the high-powered attorney representing the team, stated, "We are pleased to announce that NASCAR has removed the anti-competitive release requirement in its open agreement, which will now allow 2311 and Front Row Motorsports to race as open teams in 2025. My clients will continue their appeal to the Fourth Circuit to issue an injunction so that they can run as chartered teams, therefore avoiding irreparable harm. Both race teams are pleased that they will continue to be a participant in this sport that they love while fighting to make it fair and just for all." However, this concession from NASCAR doesn't fully resolve the team's concerns. They are now faced with a new challenge regarding the purchase of additional charters from Stewart-Haas Racing. On Tuesday, November the 26th, the teams filed a second petition for a preliminary injunction, claiming that circumstances have changed. They argue that they now face a present prospect of irreparable harm and an immediate need for an injunction is crystal clear. The crux of their argument revolves around the charter agreements they've contracted to purchase from Stewart-Haas Racing. These agreements still contain the release clause that would require the teams to forfeit their antitrust claims upon signing. Kessler argues that his clients are now faced with the Hobson's choice of whether to complete the transaction with Stewart-Haas Racing and forego antitrust claims, or forfeit the irreplaceable opportunity to purchase an additional charter. The 21-page memorandum of law in support of the motion is heavily redacted, with 3 of 4 paragraphs detailing the changed circumstances entirely blacked out. The partially redacted 4th paragraph notes that NASCAR recently allowed 2311 Racing and Front Row Motorsports to compete as open, non-chartered teams in 2025 without having to release their antitrust claims. However, it also stresses that the release would still be required in the charter agreements that 2311 Racing and Front Row Motorsports have contracted to purchase from Stewart-Haas Racing. The teams argue that this situation puts them in present jeopardy of having to choose within 3 weeks whether to close their transactions and risk releasing their antitrust claims, or forego the irreplaceable opportunity to purchase charter rights for another car. They further contend that, to prevent this immediate irreparable harm, plaintiffs request the court to enjoin defendants for the duration of this case from seeking to enforce the release in the SHR charter agreements against their antitrust claims to prevent the irreparable loss of rights before judgment. The implications for the 2025 season are significant, as open teams 2311 and Front Row face the risk of not qualifying for races if more than 40 cars show up for an event. This could potentially lead to high-profile drivers like Bubba Wallace and Tyler Reddick missing races, including the prestigious Daytona 500. Denny Hamlin, co-owner of 2311 Racing, expressed uncertainty about the team's future plans, particularly regarding their participation in the Clash in February. Hamlin said, "I don't know. I think a lot of dominoes need to fall. Sponsorship, things like that, so I don't know that decision's been rock solid made yet. But you know, things are so fluid over the next few weeks, we'll probably know more." Regarding the Clash specifically, Hamlin added, "Yeah, the Clash is always a good repetition, a representative. It's certainly one where even though you don't have pit crews there, it's good for the teams to work some kinks out. So yes, but also, you know, you're probably going to go down there and tear up a lot of stuff, so I don't know, we'll see." NASCAR, for its part, maintains that the charter deal offered was fair. During the annual State of the Sport address at Phoenix Raceway, NASCAR President Steve Phelps stated, "I know people are frustrated about that. We are not going to negotiate in the media about charters ever, and we are very happy that 32 of the 36 charters were extended because those were race teams where the deal that was put on the table for them, the primary big win for the race teams, was money." Phelps further elaborated, "I won't go into what the money split looks like, but what I will say is that the amount of money, it now puts the race teams starting in 25 as the single largest beneficiary of our media deal, and we did that because the race teams were upside down financially. However, this explanation hasn't satisfied 2311 and Front Row. They continue to push for a more equitable system that they believe complies with antitrust laws. The ongoing legal battle has the potential to reshape NASCAR's structure and team relationships. The fast-tracked discovery process could uncover more details about NASCAR's business practices and financial arrangements. This lawsuit also brings attention to NASCAR's long-standing control over the sport. For decades, the sanctioning body has maintained a tight grip, often resisting significant pushback from teams, drivers, or owners. NASCAR's history is filled with skirmishes where the France family has fended off challenges to their authority. The outcome of this lawsuit could have far-reaching implications for other teams and the sport as a whole. It may lead to changes in NASCAR's business model and potentially open the door for more equitable revenue sharing and decision-making processes. The timeline for resolving this issue is tight. NASCAR must file a response, with the teams requesting it by December 6th and NASCAR wanting until December 9th. The teams then must reply with a desired response date of December 10th, team's preference, or December 11th, NASCAR's preference. The teams are pushing for a hearing on December 12th or 13th, while NASCAR wants the court to set the date at its discretion. If you enjoyed the video, make sure to like and subscribe to NASCAR Insider and share your insights in the comments below.